And is dismissed.
Mayor, please, Your Lordship. Item number 19, Your Lordship.
19.
19.
Yes.
In this case, what happened? Two witness examined day before yesterday, Your Lordship. So,
Pardon?
two witnesses were examined.
At the trial.
Yes.
Oh.
In the trial. So, I want to take some time to get the certified copy of this witness.
Item number 19 as prayed for by learned counsel for the matter again
May
on
be fixed on Tuesday, Your Lordship.
Tuesday.
Next Tuesday. In the meantime, I shall get it. On 10th of July.
Yeah, please, Your Lord. Sir, I beg to mention item number 18, my lord. 18, my lord. TCR has been received. Can it be on Monday, my lord? This Monday. And another item 25, my lord. TCR has not been received. Can it be on 25th, my lord? February. Publish, my lord.
May I plead, Lordship? Lordship, I beg to mention item number 51.
Yes. What happened? What do you want?
Adjournment, Lordship.
When?
Tuesday, Lordship.
Yes.
Your Honor, I beg to mention for item
After a week. Date.
Lordship, I beg to mention conducting council has some
2 weeks.
Please, Your Lordship. I beg to mention item number.
Yes.
My lord, the co-accused bail application was disposed of on 3/2/2026. And TCR is lying on that, my lord. Kindly, that may be taken with that TCR, my lord. So kindly taken up to that too, my lord.
It was already disposed of.
Disposed of, but TCR is there, my lord. Even before two, my lord, that can be. Because
Come tomorrow then.
from my lord, some difficulties, my lord.
Monday.
My lord, matter may be taken as usual, my lord. Considering, because I'm seeking bail on illegal detention, my lord. May be called, my lord, on merit.
You wish.
May I please, Your Lordship? I beg to mention an bail application, Lordship, for listing.
Earlier dismissed.
Lordship, we want to.
Senior bench is there.
Lordship, we want to withdraw this for that
Huh?
on Monday.
No, you have to mention before the senior bench.
Please, Lordship, I beg to mention item number 24, Lordship.
Oh,
We have
Yes.
some personal difficulty, Lordship. Kindly, Lordship.
all right. List again on.
Lordship.
What section is there?
Lordship, it is a bail application, Lordship, under Section 480 of BNSS. Connection to Tinsukia Police Station case number 409 of 2025. Lordship, under Section 281, 125A, 125B, 3, 105, 117 of BNS and read with Section 3 of Prevention of Damage. Lordship, here the accused person, Lordship, he is a night super driver. And Lordship, on 25/11/2025, Lordship, while driving the night super, Lordship, a head-on collision occurred with an ambulance, Lordship, and resulted some casualties among the passengers.
Page 26 and 27 is the rejection order.
At CD.
Will be fixed.
May I please, your lordship? Lordship, commercial quantity, lordship, CD may be called for.
CD.
Obliged, lordship.
Foxo.
Please, your lordship. Kindly pass over the matter for time being, lordship.
Section. Notice has to go. Section 6 is there. CD not. CD within 3 days. Basically.
Lordship, this is a bail application and the accused petitioner is charged under section 443 of 376 IPC, read with section 4 of POCSO Act. And charge sheet has already been submitted, Lordship, and 2 numbers of prosecution witnesses, informant and the victim has already been examined.
Where is there? Evidence you have annexed.
Page number, Lordship. Eight and 9.
Page
37 to 41.
page 42 is the deposition of the victim. Page
42.
42.
Can copy of TCR.
Lordship, since it's a POCSO matter, informant may
Yes, notice to respond.
Your Lordship. Here in this case, Lordship, sections involved is 21C and 29 of NDPS Act. But here in this case, Lordship, that petitioner was served with a notice under section 47 stating that 21, under section 21A, he is arrested, Lordship. That will suffice the compliance of to article that has your Lordship has to see, Lordship. And apart from that, nothing was recovered from his possession, Lordship. May I pay for short date along with the records, Lordship?
Proceeded.
No, not charge sheeted, Lordship.
CD.
Obliged, Lordship. 24. Obliged, Lordship.
NDPS matter, your lordship, during pendency of the, they found out that it has already been charge sheeted and it has come before Kamrup Metro, your lordship. Can may be called, short date may be fixed, your lordship.
Admitted. Scan copy of
NDPS case number 36. Shorter date may be given, lordship. There are shorter date because your lordship, it's under intermediate quantity and charge sheet was filed after 60 days, your lordship. So there are such considerations. Lordship, if there is a case for default to be made, then your lordship objection has no precedence here, your lordship. Lordship,
If has you could have shown today itself.
we tried, your lordship, but we were not able to bring. Short date may be fixed, your lordship. If the case is not made out, then they may file objection, your lordship.
That limited purpose next week.
Obliged, your lordship. POXO matter, your lordship, also charge sheeted. So TCR will be required.
TCR notice to respondent number.
Shorter date possible. Deeply obliged, your lordship.
Kindly see para 4, my lord, para 4 and 5, page 4. Page 4, para 4, my lord.
This we can't decide on your statement.
We have to
We
vote
have
for
to
My
see the
lord,
TCR.
Then on Monday, my lord, with 4125.
Said earlier.
Yes, with BA number 4125 oblique 2025,
Again,
disposed on
with
3
BA.
2025. BA number 4125. Disposed on 3/2/2025. On Monday, my lord. Obliged.
Right. Well, this is second bail application, Millard. Earlier on, Millard was rejected and that order I have annexed, Millard.
CD.
POXO is there.
None appears. Call for the CD. Issue no-
POXO is also there.
Yes.
POXO 8 has already inserted, my lord. And remaining other 79 section is bailable. But prior to lodging this FIR, one FIR has been lodged by the informant and that was compromised by the both the parties in the police station concerned. Subsequently, compromise has been met and another FIR has been lodged by the wife of the accused person and that was also compromised by and between them. This false case lodged by the informant with a view to harass the petitioner. Time in time, he may be granted interim as well. Shall cooperate with the police station. IO of the case.
Yes, PP.
Yes, he has annexed some of the document regarding substantiate those facts, my lord.
When?
Eleven or 12.
All right, 11th CD.
Maybe set to them, my lord.
Given a short date, that is why.
My lord.
Please, your lordship, FIR is page 14 and 15, my lord. FIR is page 14 and 15. May I read, my lord?
In child marriage.
Lordship. Already, the such case and one accused has already in bail, lordship. Lordship may kindly peruse annexure to page 19. Order dated 24 to 23. Sopiur Rahman, he is on bail, lordship. He is a named accused, accused number 1 in the FIR.
Who are you?
Lordship, actually till today, I have
Husband.
stated in my petition that
You're
we
the
have not
husband.
received any summons.
Abdul Salam
I'm-
is the husband.
Husband and father-in-law.
Other person is father
Yes, lordship,
of the victim, and that was regular bail.
regular bail. So lordship, my only prayer is that lordship may kindly allow me to appear before the honorable court, and I am ready to face the trial, lordship. Because
Who is
next
stopping
date
you?
fixed on 13 2,
Who
page
is
40,
stopping you
lordship.
from appearing?
Lordship.
Go and appear. Who is stopping you?
Already one accused is already in jail, so my lord, the same FIR, my lord.
For the petitioner submits that co-accused has already been granted bail. Present petitioner to appear before the learned trial court. Accordingly, the petitioners shall go to in a period days from today. On such appearance and filing of any application, the same shall be considered as per law by trial court. Expiry of 50 days from today, that the petitioner is shall be released on 1,000 with one surety. interim protection extend beyond 15 days from today, and trial court shall file application filed by the petitioners their own merit. Petition stands.
Highly obliged, my lord. Please, your lordship. Lordship, I am extremely sorry, lordship. In item number 9, I was, if another good lordship, non-APS has been recorded, lordship. Kindly issue note.
Did you?
Deeply obliged, lordship. Lordship may fix his wrong, lordship. Obliged.
May I please your lord. The FIR, my lord, is at page 12, my lord.
SC/ST Act is also there, my lord.
Allegation is not there, my lord, but has been registered, my lord. Lord, there is a, my lord, dispute regarding eviction, my lord, in the area on the demand of Karbi student. Then, my lord, we approach the small court. The small court pass an order, my lord, we have annexed the order. The petition, my lord, is pending.
Chinese Karbi, what is Chinese
And
Karbi?
At that point, of
Karbi
time,
is go
when,
back.
my lord,
That is
dispute
the
going
allegation.
In Karbi Anglong, my lord, this type of, my
And-
lord, slogans at that point of time raised by some of the.
Now, lordship kindly see FIR filed by non-Karbi people, my lord. They are not, they have no, my lord, grievance. Third party is filed FIR. Who will cooperate, my lord? There is no
Is
other.
that regarding, my lord, anticipatory bail, maintainability of the, my lord, while SC/ST Act is there, my lord, scope is very limited. So, my lord, I will have to check, my lord, from the case diary whether that.
Lordship prima facie from the FIR, my lord. There is no allegation regarding SC/ST, my lord. Only allegation that Karbi go back. And that is the quote and unquote, my lord. Chinese Karbi. And Karbi student, my lord, they have not filed FIR. Bengali Association has filed FIR, my lord.
Registered under SC/ST Act.
Prima facie, nothing is there.
Can I exercise jurisdiction?
Lordship.
Dearest wait.
Yes, but otherwise, my scope is very limited. For that, I will have to peruse the CD, my- whether those materials, my lord, for maintainable.
All right, give a short date then.
We will cooperate, my lord, till then, my lord.
No, it's a question of my jurisdiction. That is why I am not inclined to pass order today. Because SC/ST Act is there. In the
22
city.
months.
Right.
Please, your lordship. PRS bail application, my lord. Ganja recovered, my lord, 6.85 kgs, not from my possession. I am residing in the same premises, rented premises, where from two co-accused persons were arrested. Your lordship may kindly peruse the FIR. Page 13 is the relevant portion.
Intermediate quantity.
Yes.
Intermediate quantity, my lord, and not from my possession, my lord.
My lord.
If lordship comes to page 13, my lord. The third paragraph. But you got it, my lord.
Korea area is becoming very famous. APS.
I am sharing the same rented premises with this Suraj Burman, my lord. And it was recovered from a common bathroom. 440 grams recovered from Suraj Burman, from my lord, from his scooty, and thereafter he led the police personnel. Page 14, lordship will get. Third, fourth, and
fifth description of the seizure.
Your name?
Jayanto Majumdar.
It was recovered from your bathroom.
That is a common bathroom, my lord. There is a rented
Don't know.
premises. My lord, if lordship comes to the seizure list, my lord, the house owner, he is also witness to the seizure. S.K. Bhattacharya. It is a rented premises. One person, Avinash Thakure, he was also apprehended.
What about the seizure list? What do you want to show from there?
Seizure list, my lord, if lordship comes to page 18 and 19, my lord.
Yes, para.
Number 3, my lord. 58 numbers of transparent containing suspected cannabis weighing 440 grams, including the pouch, which have been recovered from the dicky of the scooty of Suraj Burman. Then,
It is all right. That is the first part.
my lord. Then one transparent polythene containing suspected cannabis weighing 1.185 kgs, including the weight of the polythene, which have been recovered by the lead of Suraj Burman from the bathroom of the rented house of Jayanta Majumdar. But it is a common bathroom.
Keep saying it is common bathroom. Where do you show it from? We don't find the word common bathroom anywhere.
The CD will reveal the actual.
That is a rented premises, my lord.
CD.
May I pray, my lord, the short that. Deeply.
Your lordship, may I kindly see page 28, paragraph 19 of the appellate court's order, lordship. Here, the present petitioner was convicted under section 138 of Negotiable Instruments Act, lordship. And both courts, lordship, convicted him, and thereafter this revision is filed. But I'm pointing out one legal aspect, lordship, that 138C, that is not complied. And therefore, lordship, that cause of action has not arose while filing that at the time of filing the complaint, lordship. Paragraph 19 will make it clear, lordship. May I kindly say page 28, paragraph 19. That 15 days time after receipt of notice, that is required to be given. That is mandatory, and Honorable Apex Court judgment is also there, lordship is aware.
Page 28.
Yes. Of my petition, lordship. Appellate court's order, paragraph 19, your lordship will get. Paragraph 19. The notice was issued on 25/9/2018. And the appellate court observed that in ordinary course of post, it ought not to have taken more than 1 week. So even if we add, lordship, 7 days, then it will be 2/10/2018. On that day he received. And complaint was filed on 11/10/2018. That is prior to expiry of 15 days period, lordship. The complaint has to be filed after 17/10/2018, lordship. Because 138, she says that the person has to be given 15 days time. If he does not repay the amount, then only cause of action will arise. But still the act, and the act is also clear, but still also I am placing one judgment of Honorable Apex Court, lordship. Paragraph 9, lordship. In fact, that said complaint was quashed by the Honorable Apex Court. Paragraph 9 is the relevant paragraph. It is stated that Lordship that he admitted receipt of notice under in his statement recorded under section 313. But the relevant date will be relevant here, Lordship. Because merely acceptance after filing of complaint will not suffice that conditions, Lordship. So that date has to be there. And in 313, that date was not asked to him, Lordship. Complaint was filed premature.
25/9/18 is the date of issuance. 7 days therefrom would mean
Here, Your Lordship, 25/9/2018 is the date of issuance of notice. So the appellate court says that ordinarily it takes up to 7 days. So if we add 7 days, it will be, Lordship, 2/10/2018. On that day, he received the notice. And from that, Lordship, 15 days period has to be given to that.
till 17 he had time.
Yes. After 17, he has to lodge the complaint. And here they have lodged the case on 11/10/18.
Your answer to that, respondent?
Was issued on 25/9/2018. Complaint filed on 11 after 17 days. After 17 days.
10 days from date of issuance, not from the date of receipt.
But actual date of receipt, my lord, that was not before the. My lord, this question was never raised before the appellate court. He admitted that he issued amount he has.
Current issues.
Only thing is that, my lord, the appellate court had assumed that the notice served within time frame. Assumption has been drawn. Section 139, my lord. It has been exercised. My lord. Says, my lord, it shall be presumed unless the contrary is proved that the holder of a check does part or any debt under 139 second presumption.
No, I still don't find you explaining how it could have been filed before expiry of 15 days.
But can it be taken on Monday? There,
Is not an issue, only the legal aspect is there, Lordship.
Can't improve this. What has been written there?
Lordship may keep it as part, he will address to that, or because I have already submitted what is there, Lordship.
that can be.
Part in part, list again on. Monday,
Nine.
otherwise I'll forget again.
Obliged, Lordship.
May I please your lordship? May I please your lordship? Lordship, by the order dated 21/2026, your lordship, an report was sought from the Honorable Trial Court regarding the service of notice to the guardians and to the accused, whether those notices were served or not. The order dated 21/2026 reflects that.
Seen the TCR.
What is there, my lord? There is flag mark, my lord. In the, my lord, main file, my lord, itself, my lord. Flag A, my lord.
T8, ground of arrest, blank. Can't improve this by any way. Totally blank. Question of service, non-service, of receipt, nothing does anymore. Had learned counsel for the petitioner. Had learned additional PP decision application for. So
My lord, without going to the merit, only on, my lord, Article 21.
yes. Why should we go elsewhere?
My পয়সা অধিকার বেশি
Briefly put, the prosecution case is that what was the quantity?
359 grams, my lord, of heroin, my lord.
Grams of what?
Heroin, my lord.
Suspected heroin was recovered from the possession of the accused on 27/5/2025.
9 is without soap cases. Otherwise, my lord, with soap cases, total is, my lord, 1,170 gram.
The soap cases, do we? Yes, where it was
In a car, my lord.
a vehicle.
Vehicle, my lord.
Filed the petition. One petitioner or two?
One petitioner, my lord.
Maguri. Short point raised by learned counsel. Non-service notice. Compliance with 8 BNSS which just writing to the is available. Of the notice, purported notice under section 8 BNSS reveals that grounds of arrest that against the column where the grounds of arrest required to be mentioned, the space has been left totally blank. In other words, no ground. The stroke friend the arrest illegal directions of the IO open for the IO to court. This instance disposed of record.
Can it be one government COT? One government COT, my lord. Because of my lord commercial quantity nature, only because
Local person, my lord.
that is obviously there. He is a local resident of Khojai, my lord.
Khojai, my lord. So, my lord, difficult for a poor person to arrest them.
It been any other matter might have insisted, but since the arrest itself has been rendered illegal, we cannot impose onerous conditions.
Obliged, my lord.
But as per Mihir Sahib, now you can again apply for arrest.
Yes, my lord. Mihir Rajesh sir.
Please, Lord. Hearing the petitioner, they were arrested on 16/3/2024 and they are in custody for 692 days. The present stage of the trial is to be, I think the present status, Your Lordship, my friend can say, Your Lordship, better, Your Lordship. Now my point herein is
This is what NDPS, commercial quantity, NDPS.
Yes.
The detention, you are seeking on ground of detention,
Yes.
length of detention.
Yes. No. Page 44, Your Lordship, kindly have a look. Page 44. The notice served under section 50 of the CRPC, Your Lordship. Yes, people. Page 44 and 44 and 45. They are the divers and co-divers, Your Lordship, and wherefrom allegedly the ganja was recovered.
Don't want us to go to page 46. Arrest
Yes.
memo. First come seizure memo. Your signature is there, I think. What is your name?
এটা নাকি?
Signed in Hindi.
Yes. তেজব নাকি? এটা কি? Like that.
Just Ms. Chaudhary.
I'm a bit handicapped today.
All right. At the same time, try to find out the
Page of
section
that,
50 notice per se appears to be deficient, but
Lordship.
as far as the search cum seizure memo is there, all the grounds of arrest, everything is contained there, and those have been received.
I'll look into that, Lordship.
Look into that aspect also. Yes, when do you want?
Can it be on 17th, Lordship? 7th, Lordship?
Tomorrow. One, huh?
17th.
17.
1/7.
7th, Lordship.
Crowded by now. The prayer of representing NCB. 12.
12.
I am told, though it's on NCB,
Item number?
Venting Lordship.
Yes, দেখো।
Submitted that the
Yes, yes.
has been
মুড়ি মুড়ি কেমন? We're going to be prefer.
May I please, my lord? My lord, in this case, my lord, informant lost the affair in this effect that, my lord, the daughter of the informant, my lord, found to be hanged dead in the house of the petitioner number 1. She is the wife, my lord, of the petitioner. And that was communicated over telephone, my lord, to the informant. And my lord, the petitioner, accused petitioner number 1 took her into the hospital. Then, my lord, informant reached the hospital, my lord. Subsequent that she expired, my lord. Then the informant lost the affair that the accused petitioner
PM
murdered.
report is there.
Did you receive, my lord? The PM report and final opinion is also available, my lord. From the PM report, initially opinion regarding cause of death has been kept pending till the receipt of histopathological report from the Department of Pathology, MCS. And now, my lord, final opinion, my lord. Final opinion of the on reviewing the case in the light of the histopathology report from Department of Pathology, GMCS, and postmortem findings, I am of the opinion that the disease so and so have died due to pulmonary edema as a result of antemortem suicide. Case is registered under 1031, my lord. Not yet added, my lord. Otherwise, from the materials.
And my lord, behind them are 78 days, my lord. I have, my lord, small child, my lord, 8 years, my lord. Presently, my lord, that is looked after by the
Third learned counsel for the petitioner.
PM Hassan.
Along with postmortem received and as suicidal. Hence, section 1. NS is not at the present. Para having regard to of detention of
78 days, my lord.
78 days custodial detention of the petitioner. Allowed the further provided that the petitioner self cooperate with the try to influence in any manner.
My lord, lordship may interim order pass in respect of the petitioner number 2, my lord, that may be absolute, my lord.
Interim order.
Yes, my lord, in respect of petitioner number 2, my lord. Deeply obliged, my lord.
My please, your lordship. Here in the petitioner, they were in custody for 101 days, your lordship, they are in custody. And from this 3 person, your lordship, allegedly 75 kg ganja was recovered from 3 different person, your lordship. Page 12 is the FIR, your lordship, kindly have a look. From the petition number 1, it was 18.8 kg, and from the petition number 2, it was 18.8 kg, and from the petition number 3, is
Can they be counted separately?
Yes, separately. But I am not on that, your lordship. But here in your lordship,
Together.
All of them together.
page 18 onwards, your lordship, kindly have a look. These are the notice served under section 47 of the BNS. So all the petitioner, they are the illiterate person, but the notice has been served in English. Page 18 onwards, your lordship. Eighteen is in respect of the petition number 1.
But they have signed in English also, my lord. Their signatures in English, my lord.
And page 22, your lordship, kindly see, the thumb impression has been given here. Is the petition number 3, your lordship. But in my petition, I have stated that all the petitioners, they are the illiterate person, your lordship.
How can you sign in English?
They
You're
don't want
illiterate.
To sign, your lordship. No, only to sign, your lordship.
You can sign your literate as per government definition. Literate means angutha chap.
Yes, yes. Some persons are there, your lordship, they
go to sign in English.
Can prove in trial, but for this purpose, prima
no
facie, your
prima facie.
signature in English is there, so we'll presume you know English.
Lordship, disregard your lordship, one judgment I would like to.
Which one?
Mihir Rajesh, your lordship.
That doesn't say that you
Notice
deal
is to
with
be
this
served
matter.
in the language in which the arrestee understands.
Yes, you understand English.
No,
Sign in English.
Since you signed in English,
no,
we'll
please,
assume you know English.
I have made a specific statement, your lordship, in this regard, para 5 of my petition, your lordship. Can
You can be prosecuted for making false statement before the court.
para 5, your lordship, kindly have a look, your lordship. Although the petition number 1 and 2, they put their signature in English, but the petition number 3, he has given thumb impression, your lordship.
How many petitioners?
3 petitioners here.
Who has given thumb impression?
Petition number 3, your lordship.
Page?
Page 22.
Thumb impression as well as signature. Sanjay Singh. Signature is also there.
Actually, he was given by somebody, your lordship. Page 23 also thumb impression. My only contention is that, your lordship, that although the notice has been served, but it is not in accordance with.
The notice, my lord, if it.
I am not disputing
Or
that,
that,
your
my lord,
lordship.
perhaps they are not
I
prejudiced.
am
my
not
lord.
disputing that, your lordship. The question is that
They are not prejudiced, lordship. In the order also, I have flag mark, my lord, initial order, they have. That order is also there.
the purpose of giving the notice, your lordship, so that the person can take defense, your lordship. But here it,
Their signatures are also in English. They have no English.
sir, is English, it doesn't mean that they know the English.
But they have know about the facts, my lord.
They have stated.
Red-handed, my lord. Their possession, it was recovered. Knew about that, my lord. Formalities, my lord. They have got red-handed.
No. Not formalities.
They have got red-handed. They knew.
But Annexure 5 as submitted by council, thumb impression, that means IO has written this name, Sanjay Singh.
Yes.
While taking the thumb impression for the purpose of identification.
And the same fact, your lordship, in 48 also, your lordship. And that 48 notice, I think it is within the LCR.
Where is it?
48, I have not annexed, your lordship.
Then without annexing, you are submitting.
No. 48 year also.
Do you want to submit about 48?
Same submission, Your Lordship. Same submission, Your Lordship. They do not know, Your Lordship.
The WhatsApp messages. 8. 48 seems to be WhatsApp messages. The backside of service.
Council,
Counts are there, but where is the service? Signature of informed person, blank. That is because on the next reverse side it is WhatsApp message. What's the decision regarding electronic message?
I have no instruction, Your Lordship, regarding that.
Will
Whether
instruct
it
you.
was served in.
Your
what-
client will tell you which decision.
service of notice.
But so far, Your Lordship, their judgment is concerned, Your Lordship, the notice is to be served prior to. Towards prior, Your Lordship.
Absolutely. All right.
Apart from that, Your Lordship. Regarding the petition number 3, Your Lordship, he has recently undergone a critical operation, Your Lordship. Relating to brain tumor, Your Lordship. So
Number
Lordship, I have some medical documents, Your Lordship, regarding the petition number 3, Your Lordship. I will hand over, Your Lordship.
yes.
Being charged with section. Lordship, this person is being bars for over 4-7. Lordship may find the FIR at page number 10.
Yes, PP.
My lord, here I have gone through the record, my lord. He has cut his wife, my lord, and surrendered before the police station, my lord. And till today, one witness examined, my lord. And from the witness, my lord, it reveals that he has committed the same report also several. And
What about the this on behalf of both?
Comment.
One.
my lord. My lord, my humble submission is that it is not a case, my lord, to grant him bail, my lord, as the offense is very serious in nature, my lord, and he himself cut his wife, my lord. And some of the witnesses said that he also demanded money, my lord. In the initial, he said that no demand is necessary, but after marriage, my lord, he also demanded money, and for that there is a dispute, my lord. Cut his, my lord, wife, my lord.
Factors are to be taken in by Lordship. Lordship, there are, Lordship may say that there are listed witnesses, 18 listed witnesses, Lordship. The only witness which is related to the person is the informant, Lordship, and he has already been examined.
Some material
And
witnesses
there is
yet
no
to be
other,
examined.
there is no other witness which is an eyewitness or anybody else, Lordship. And Lordship may appreciate the Supreme Court has time and again reiterated that inordinate delay cannot be a reason to keep a person inside, Lordship. Charges were framed way back in March 2025, and till today only one witness has been examined.
The reason for that?
Orders, my lord, and size frame on 13/3, my lord, 2000. One witness examined, my lord. Finally, page the PM report. Of injury.
As a 2-year-old child outside with his grandparents.
Better
My
that
lord,
he be
even
kept
if he's-
away from you.
My lord, even if he's know about this, my lord, he has killed his wife, my lord.
Third learned counsel for the so and so.
Sarcitic cases can.
There's the postmortem report.
My lord, my lord.
Is life. Gravity of the offense. Detention for how many days?
475, Lordship. 475.
475. trial where vital witness.
Please, your lordship. Till 632 days, 1 year, 9 months. The petitioner is behind the bar, lordship. Here is a POXO case, my lord. Date of incident was 11/5/2024. FIR lodged after 4 days, that is on 15/5/2024. In between what they did, we don't know, lordship. And interestingly, there is no ground of arrest. There is no ground of arrest mentioned, which is mandatory. And lordship, almost all the evidences are recorded, cross-examination done. Only one official witness, that is the IO, remained. And then last stage of trial, lordship. And lordship may kindly peruse page number 73. Page number 73, the vital medical report. That is medical officer's deposition. Sign of recent sexual intercourse not seen. This is the most vital part of this case, lordship. 73, the witness of the medical officer. And in the cross-examination, which is at page number 74, lower portion, point number 7, hymen rupture may be ruptured, but cycling or some sports activities. This is clearly mentioned in page number 74. That is the cross-examination of the medical officer.
Okay.
And lordship, the boy, the accused person, which is just 18 years crossed at the time of occurrence of the incident. There was a love relation, lordship, and the record reveals there is no ground of arrest in form. Mandatory. It more than 3 times. No objection filed by the inside. Page number 34, 36, and 38. These pages clearly states that the informant has no objection. In spite of that, our bail has been rejected on several occasions by the trial. That's why this petition has been filed before this honorable.
Submitting about ground of arrest.
Ground of arrest, nowhere ground of arrest is mentioned. In the notice, in the 50 notice.
Yes.
Lordship. Informant Lordship in this. Earlier stated also that I do not have any objection. If matter of the and I
My last submission, Lordship, I have to say that there is no sexual intercourse here. What he has done, already he has behind the bar, he has suffered a lot. 1 year, 9 months behind the bar. And in this stage, Lordship, a teenage boy, Lordship. The date of incident, he was just 18. My lord, may kindly humanitarian ground that is bail application because of the future of the accused person.
Include her LURE. Trial of the case is at the penalty stage and the victim the IO has already prisoner has it is
632 days, Lordship.
trial is almost over. Violation of trial court.
Oblige.
It, your lordship. Here has received but service not complete, lordship.
I have checked the, my lord, there is no office note, my lord, regarding the, whether they have taken the steps or not,
Steps taken, lordship.
but no any office note.
Taken, service not complete, lordship. The last 5 months, lordship. Trial has not progressed, lordship. Short date, lordship.
Why not through police station?
Hello?
Why not through police station?
My lord, now, my lord, it is sent to the, my lord, registry, my lord. Registry will send back to the PP office, my lord. Then PP office will transfer it to the, my lord, concerned PS, my lord.
Have taken steps.
First, it will go to the registry, my lord. Then PS, my lord.
But in the order, there is no, it is not mentioned the manner in which steps are to be taken, whether
The POXO case, that manner it was taken, my lord.
you have taken how? You have taken through registry or
For the registry, lordship.
As per Deepak Nayak case, my lord, it was decided in Deepak Nayak, my lord.
by registered post?
Lordship.
Steps are taken by registered post also sometimes.
Sometimes, lordship,
But in
if it is
POX
not mentioned.
If in POXO cases, my lord, that format is, my lord, process used, my not direct to the, my lord. What, my lord?
Does not reflect whether steps have been taken. And copy of TCR has second time only.
So first time,
First bail application, lordship.
Second listed for the second time only.
Lordship.
second time, my lord.
Whether steps have been
Can you go on 13, lordship? 13 to lordship. Oblige, your lordship.
Here has received my lord.
Similar, my lord, in this case also, my lord, in same, the office note, there is no mention about.
then
I
same.
have taken step, my lord. Only one thing, my lord, may I submit, lordship. The default bail as well as my lord, section 47 notice, my lord. Notice, my contention, it was not served, my lord. They have, the record reveals that there is a copy, but there is no date on that notice, my lord. I have annexed, my lord. Your lordship, page 21 onwards, my lord.
Been served, it's a.
My lord.
Clear notice, my lord, not sir, my lord, as per the my lord guidelines, my lord. Of my lord, hearing, my lord. Heard, my lord.
It involves violation of Article 22, then.
Then also perhaps, my lord, for my
Any stringent condition, my lord. My lord, page 21, my lord, is the 47.
case also, my lord, for my
Nowhere it
immediate
is
understanding.
mentioned when it was furnished, my lord. Even the learned
But-
magistrate who has seen, he has also not put the date there, my lord. Page 21 at the top, my lord, the in charge STJM, my lord.
21 of.
Page of my bail petition, my lord. My lord, issuing authority, page 23. At the bottom, my lord, his name is there, there is no date, my lord. And the learned magistrate who has seen, he also not mentioned when it was.
It will be revealed, my lord.
Certified copy, my lord. I pro-
Twenty-two, my lord, there is a date and time of arrest, my lord, that's 15/25, it has mentioned.
Arrest is there.
Yes, that is there.
Date is there for arrest, my lord. But when it was furnished, my lord. As per Mihir Ranjan, my lord, it is required to be furnished within 2 hours prior to production, my lord. There is no date in that particular notice, my lord. The issuing authority at page number 23 at the bottom, my lord. Samdash is there, my lord. There is no date, my lord. And he was arrested on 5/10/25 at 11 PM, my lord. It is there, my lord. These are all typed copy, my lord. And even, my lord, the learned magistrate also, my lord, he has seen, there is no date, my lord. My lord, with due respect, my lord, Mihir Ranjan judgment, my lord, para 56, were to be furnished prior to 2 hours before production, my lord. There is no date, my lord, in that particular notice, my lord. My lord, I may request, I will pay the order, my lord, for effect. Lordship, para 56, my lord. Case whether arresting officer or person is unable to communicate the ground of arrest in writing on or soon after arrest, it be so done orally, the said ground be communicated in writing within a reasonable time, and in any case, at least 2 hours prior to production of the arrestee for the remand proceeding before the magistrate.
It has also mentioned in para 58, my lord, henceforth is there, my lord.
The date.
Date of arrest and date of
The date of arrest is there.
Is the date of the judgment.
judgment.
My lord, date of judgment is, my lord, of lordship, 6th November 2025, my lord.
Later, my lord, then it will be not applicable, my lord. Date of
It's
arrest,
November, this is arrest is on December.
December.
5/10. Date of arrest 5/10/25,
5/10.
my lord. Date of judgment is 11th November, my lord. November, my lord. This is
Will
earlier,
not
my
be
lord.
applicable then.
My lord.
Then my default part is also there, my lord. The part charge sheet, my lord. There is no concept part charge sheet, my lord. Charge sheet, there specific clause is there, my lord, that because of insufficient evidence, they could not submit the charge sheet, my lord. Final charge sheet. Lordship, page 24 is the charge sheet, my lord. Part charge sheet part is there. Number 4, part charge sheet, my lord. And my lord, page 26, any remarks, special remarks, including reason for not charge sheeting. No, to cause insufficient evidence, my lord.
Charge sheeting whom? Only one accused.
The part charge sheet, my lord. And the concept of charge sheet, my lord, it should be completed within the statutory period, my lord. Here, they are saying that it's part charge sheet, my lord. Meaning thereby, my lord, charge sheet, the investigation is not completed till date, my lord. And by submitting part charge sheet, my default bail right cannot be precluded, my. So that count also, my lord, I am entitled to. Condition, my lord.
This is only DNA profiling report is pending.
My lord.
His investigation is over.
They may file supplementary also. my
Yes,
lord,
they can
at
file
any time, my lord.
supplementary. FSL doesn't give him the report. What is
For the want of my lord, FSL as well also my lord, part charge sheet would not be my lord, debar him from getting.
where is the judgment? This aspect of the matter has already been dealt with by the session judge. Regarding filing of part charge sheet, he has held it is not a part charge sheet. Because everything is over. Now, what is the stage of the case?
My lord, the appearance stage only.
How many days?
My lord, from 6/10/2025, my lord.
report, it is an enclosed inspection memo, arrest memo, intimation to the arrested accused. So that date itself, it was served. Prima facie. The technical aspects are gone.
My lord. And regarding the merit, my lord, charge is not framed, my lord.
Wait for respondent number 2.
My lord, that service is not yet, they have not, as per office note, my lord, no office
I have
note
taken
is-
step on 29 itself.
Since that technical aspect, my mind, constitutional aspect is no longer there. Wait for the
My lord.
আগৰ কেছটো last order. Yeah, it will be the same order here. Previous item. Item 26, I think.
A short date maybe.
So giving short date is
Fine.
no meaning because of unless notice is not served.
Prior to date, my lord, 2nd March. There is only 4th mile. 6th mile.
6th,
6th February.
Today is 6.
6th February, mile. March will be 2.
give a date in February. 3rd week of February.
Third week of August.
May I please, Your Honor? And it is an application under 483 minute. I am 261 days before, 264 days behind the bar, minute. I have annexed the judgment of the co-accused has been enlarged on bail by the Honorable High Court, madam. And no evidence has started, madam. On last occasion, order dated 26/1 reveals that that witness have not come, my lord. Page 28, my lord. Accused Abdul Majid is
It was supposed to be
judicial
listed before
custody.
another bench. It is not available.
Beg your pardon?
I said.
Twenty-one B.
আছে তো। Same order যদি
21B, my lord.
Where is the order?
Order is, my lord, I have annexed, my lord, at last page, my lord, your lordship will find the same case, my lord. Page 38, annexure 6, my lord. There are other technical points are there also. So I don't like to hesitate, my lord, only detention, my lord, 264 days.
Intermediate quantity.
Yes, my lord. There are other judgments also of the honorable.
This bench is not available. Why has it come here? It should have gone there. Bench which
But it was not rejected. Same case, my lord, that's why. So, I think on that point, there is no bar. If it is rejected, then it would go to same court. Oh, yeah. That I don't know.
Stand on the same footing.
Beg your pardon?
Stand on the same footing.
Yes, yes.
Oh, the
Yes.
present petitioner and the one who has been granted bail.
He was also arrested in the same case. This is the same case.
Same case, but are the allegations same?
Yes, yes. My lord, they were traveling in auto rickshaw. A bag was found.
Both.
Yes. The other co-passenger also there.
Days will be number of days.
Number of cases, my lord?
Days. Number of days behind bars.
Oh, my lord, 261 days.
Yes. All right.
Problem.
May I please your lordship? For reason I did not make submission before this court. Now I have obtained instruction on interim and I have already appeared before the IO and my statement has been recorded. Here, Annexure A, page number 9, your lordship. Informant is a married lady, lordship. She said that.
But she appeared.
My lord, here, lordship, kindly pay last order, my lord. Here, the interim order was vacated, my lord. My lord, regarding the case, my lord. Last occasion, my lord, 2-2.
Now today he says he has instruction. What
My
is the
lord,
instruction?
My lord.
Lordship, I have already been appeared before the investigation officer. My statement has been recorded by the IO, lordship. My lordship, I approach.
That is not available.
My lord, here and here available, my lord.
Available.
My lord, here I have received a case there, my lord. From the, my lord, case there reveals that there his involvement is committed the offense by blackmailing and taking all the documents, my lord, PAN card, voter ID, and the birth certificate of the, my lord, son of the, my lord, victim. And in 183, she has categorically implicated, my lord. And lordship, and the IO note also said that, my lord, he has denied all the allegation denied, and he is not cooperating with the investigation, and said that, my lord, he has not received any PAN card, Aadhaar card, etc., etc. And that's why, my lord, IO has paid for recovery of the that portion, my lord. IO has paid for, my lord, custodial interrogation, my lord. Asime kindly peruse, my lord, her 183 statement and husband's statement, my lord. What kind of man he is, my lord.
Husband of victim.
Victim, my lord. Victim. Conduct, my lord. Captain Lordship, may kindly page 183 statement, my lord.
Willingly goes to the hotel 15, 16 times and claims he is forcibly raped.
That is why.
Married woman.
My lord, from the 183 statement, blackmailing, my lord, he has taken the, my lord, from all the voter ID card, my lord, that are even the birth certificate of the, my lord, son of the victim, my lord.
That is only the false allegation against me, my lordship.
Can you blackmail someone with a voter card?
My lord.
That is the.
How can you
online
blackmail
is
someone with a
available, your
voter
lordship.
card?
From the statement of the husband also, my lord, it feels, my lord, what type of person, my lord, the conduct is what type of conduct, my lord.
Maybe a very bad person, but all his actions may not be illegal. If it
Release
is.
the FIR itself, lordship. That is also contradictory, lordship. FIR page 9,
And
your
last
lordship.
portion, my lord, I will note this, dear, my lord, that lordship kindly page. Last page, my lord.
That's to the same lordship. One cause FIR has been lodged by my wife, lordship, but initially the same has refused to restart, lordship. Being aggrieved, lordship, my wife has filed one another application before the SP, and thereafter, lordship, case has been registered against the informal lordship and her husband, lordship. That is the Kajolgaon PS case number 191/2025. I think it has not been recorded, lordship. They have concealed the fact, lordship, under such section, your lordship. That is 17/12/2025. Only by the interference of the Superintendent of Police of concerned district, lordship. That is my application, lordship. And one another reminder notice I have sent to the concerned PS, lordship. That is on 12/12/2025. Only thereafter, lordship, case has been registered, lordship. The entire aspect, lordship, entire fact I have enumerated in my FIR, lordship. What is going on at that time? Even your lordship, the FIR itself, lordship, Annexure A, page number 9, lordship. That is, she itself stated that, lordship, that I have been coming into love relationship with the accused person. Accused person relation with his wife is going on bad. By taking such advantage, your lordship, the informant said that I have loving relationship with him, lordship. See, knowing entire fact, lordship. Then, lordship, the accused person relation with his wife is going on bad. That is why he has kept my ATM card, Aadhaar card, voter ID card, PAN card, and the birth certificate of my son. This is totally fraud, fact, your lordship. So, lordship, birth certificate, why I may be required, lordship? She has a family, lordship. She has a husband, lordship. And if the knowledge of her husband, lordship, can I restrain her PAN card and her son birth certificate? Can it be possible, lordship? So it is the online mode, lordship, available on online, lordship. Why it may be is required for me, lordship? That is only the baseless allegation, lordship. So, lordship, in my cross FIR, lordship, in this case, lordship, I have FX Annexure B, lordship. That is 26/11/2025, lordship. Page number 13, lordship. In the cross FIR filed by my wife, lordship, all the facts has narrated in the said FIR, lordship. Can be perused, lord. And the entire scenario will be come up. Times I appeared before the IO Lordship, my statement has been recorded. But I have denied that same document has not under my custody, Lordship. The alleged allegation against the such and such document I have kept without their consent. Can it be possible, Lordship? PAN card, voter card, why it may be required for me, Lordship? That is available on online mode, Your Lordship. And Lordship, one I have a Hyundai Venue car, Lordship, at the time of quarrel, Lordship, disputed arised between us, Lordship, same has totally been damaged, Lordship. When Lordship and the said vehicle has seized by the police person in presence of the traffic police at the place of occurrence, Lordship. In my FIR Annexa B page number 13, that has to be categorically mentioned, Lordship. The last paragraph of this of the said FIR, Your Lordship. May I please
You were supposed to deposit the mobile phone on 30/12/25. But after that, there is no entry.
And Lordship, one mobile, I have mobile phone, Lordship, presently under their custody, Lordship. Done to me, Lordship. I have a one mobile phone, Lordship, but same has been into their custody, Lordship.
There means
Return me. Your Lordship, in the FIR filed by my wife, page number 13, in the last paragraph, kindly peruse, Lordship.
Excuse, my lord, that is after that, my lord.
No, not after that. Only to the default to registration of the such FIR, Lordship. Being aggrieved, Lordship, I instantly approached before the officer in charge, Lordship, by intimation, by sending one intimation letter, Lordship. That is the reminder letter that officer has a duty bound to register the case under such and such provision, Lordship. And thereafter, Lordship, non-compliance of the such.
His IO has not mentioned whether he has submitted the mobile or anything in the CD.
Last part, my lord.
Yes or no, nothing. About the MLR only.
Last page, my lord, there is a last page.
IO issued notice under section 94 of BNSS. Produce him the documents and the mobile handset in 30/12/25. The next entry dated 17/1/26, there is no mention of anything.
My lord, here in regarding 94 notice, my lord. Last page, my lord.
IO probably does not know that order has been vacated. You have not cooperated.
No,
Not
Lordship,
appeared
two
pursuant.
times, Lordship, I have appeared before the IO, Lordship. My statement has been recorded, Lordship.
It's under section 94. Did you appear on 3012? No.
Probably, Lordship, notice has not served upon me, Lordship. Yeah, I have appeared. Even your Lordship, when my interim protection is granted by this honorable court, on that day, the Lordship police personnel was visited my house and I was kept to the police station. The and Lordship 7 hours has kept in the police station, Lordship. Then thereafter, Lordship, myself, Lordship, through his counsel, Lordship, I have communicated to the officer in charge, Lordship, and Lordship asking, then approached him, Lordship, that interim protection has been granted by this honorable court, Lordship, and sending the same through WhatsApp mode, Lordship. Then thereafter, he was released from the police station, Lordship. Lordship, 2-3 occasion, Lordship, I have appeared before the IO. So, Lordship, if required, Lordship, call for the up-to-date case diary, Lordship. In the meantime, interim protection may be continue, Lordship. I will cooperate with the investigation. Duty, Lordship. My mountain duty, Lordship. In the event, Lordship, I have clearly stated, informed to the officer in charge, Lordship, that I have nothing, any documents under my custody, Lordship. Your Lordship is the PAN card and the Aadhaar card. Same has been available on the website, Lordship. Online mode, Lordship. Why it may be required to sustain such and such document under my custody? What will be benefited, Lordship?
And if there are any photographs and videos, those must have been deleted by now.
With her husband consent, Lordship. Can it be possible? She has a family, Lordship. Why her husband has allowed me to domain such and such document under my custody, Lordship? What is the false and fabulous allegation against me, Lordship? Itself, FIR stated that, Lordship, that she become love relationship by taking advantage that his relation with his wife has come down, Lordship.
But
Had no good relation. That is why, Lordship, he made illicit relation
remaining part is in the city,
with her, the
after
consent
FIR,
of
my lord,
his
remaining part in the city, my lord.
husband, Lordship.
There is a, my lord, photo.
What is the baseless allegation against me, Lordship?
Video, my
That
lord.
is, Lordship, baseless allegation. Nothing, Lordship, in this FIR, Lordship. What is this, Lordship? He has made illicit relation with me with the consent of her husband. Can it be possible? Can it be justified allegation against me, Lordship? What is going? The FIR itself says that, Lordship. Then accused was raped me without my consent. Even she stated that the first line, Lordship, that she fall in love with him. Even she know that he has a wife. But only because that she fall in love, that he has then not any good relation with his wife. That is the allegation, your Lordship. What is, Lordship? So, Lordship, I will cooperate with the investigation officer. If required, call for the up-to-date case diary. Till then, my interim protection may be continued, Lordship. It is my bounden duty, Lordship, to cooperate with the investigation officer. I am always ready, Lordship. And the earlier 2-3 occasions I have appeared before the IO, Lordship. And Lordship, last page of this, my application, Lordship. Kindly see, Lordship, Annexa B, page number 13, Lordship. My wife has narrated entire fact, Lordship. And subsequent release states only to interference of the concerned SP, Lordship. The same case has been registered, Lordship, against the informal, Lordship. That is on 17/12/2025, having Kajolgaon PS case number 191/2025, Lordship. Same has been affixed on record, Lordship. Annexa B, page number 13, and the last paragraph may I please to read, your Lordship. After the accident, my husband managed to run away from the spot out of fear, but the accused person caught hold of Duitan Nazari, dragged him to the outside of the road and beat him brutally with bamboo stick. Wooden stick, kicked him and punched him on his purse. They beat him senseless one of the traffic police personnel witnessed the entire incident and after the incident took my husband damaged vehicle to the traffic police personnel. So at the place of occurrence, Lordship, the traffic police was present. And thereafter, Lordship, when my vehicle has been caused damage, Lordship, same has been carried out with the assistance of the traffic police, Lordship. Then, Lordship, the FIR has been totally false, Lordship. So it may be, Lordship, there is a quarrel between the parties, Lordship, arising out of the such and such dispute, Lordship. So both are married, Lordship. Both have a respectful spouse, Lordship. Then, Lordship, both are fall in love. Even Lordship, same has not, I have not submitted with the record one marriage agreement has been made out between these Lordship. But I did not produce the same with on record, Lordship. That is one the marriage agreement. Even Lordship, while I was fall in love, Lordship, at that time, Lordship, number of times, Lordship, I have sending money to her and she has taken by our love and relationship, Lordship. And thereafter, Lordship, she again demanding money, Lordship. When she demanding money, when the matter has been came upon before my wife, Lordship, matter has become difficulty arising out of their love relationship, Lordship, and I refuse to pay, then agreed, Lordship, the present FIR has been filed by the informant side.
Per her statement, sending her obscene videos. So that phone she could have supplied to the police. Will not self-incriminate himself by sharing his mobile. Even if he surrenders, they will not find anything now. He will have said everything. If at all there was anything. Yeah. Admittedly, having a love affair with another married man as many as 15 times was not consensual. Get an opportunity to make videos as alleged. Allegation against the petitioner is that did rape upon the victim lady by resorting to blackmail after videographing recent photographs, recording indecent photographs, the victim in his mobile phone. This call for has been produced. Statement of the victim, other witnesses, appears that sadly the married lady was in love with having a love affair with the petitioner, who is also a married person. It also feels that they had visited different hotels on occasions. Intercourse between them is which the victim claims to be against her consent. Pursuant to interim protection granted by this court, had appeared before the IO, and his statement has also been recorded.
Part may be recorded.
So the IO has noted that the petitioner has not been cooperating with the investigation. He has not surrendered his mobile phone despite it. Willing to stand before the IO. Recalling CD.
I'm obliged.
Please, Your Lordship. Your Lordship will find at page 9, there is no allegation against the present petitioner's Lordship. They are the parents of the FIR name accused person, Lordship. And they apprehend because police failed to arrest that Aditya Jaiswal, Lordship, and accordingly they threaten the petitioner that they will arrest them if they do not produce their son before the police station. On that apprehension, they approach before the.
My lord, here both of them in my lord, CD not received to them.
I did not interim order passed earlier to continue.
Okay.
Listing.
2nd of March.
On 5th, Lordship.
March.
Obliged, Lordship.
Not received, my lord.
Interim, my lord. List again also, and so interim. Continue.
5-3, my lord.
Steve. All right. Yes, next.
Lord,
Service completed, my lord, as per my instruction.
Respondent number 2. Huh? 3 and 4. Respondents.
petitioner.
Appearing, of course. Serve copy on amicus curiae. Listing.
To forward you to and portion of the FI is it
Yes.
is that 20 numbers of cattle has been transported using channel number 1, your lordship. Channel number 2 is the received purchase receipt, your lordship, of those cattle, your lordship. My lordship, the earlier occasion, your lordship, we the privilege of appeared, your lordship.
Have they appeared?
Appeared, your lordship.
Appeared statement recorded. Their statement it revealed. Cattle. Examined before loading. He is the owner of the vehicle, petitioner number license for trans.
Should bear the owner, nothing authenticated, your lordship, because
Different aspects. Oh. Okay, here on. And cattle.
May it please your lordship. The allegation is that some cattle traps were stolen, your lordship. Aye.
Kindly taken up after some time.
What happened?
Because I have to, my lord.
Congratulations.
May I please, Your Lordship? But this is a charge sheeted matter, my lord. 10 cough syrups, my lord, recovered from a pharmacy, my lord. And owner of the pharmacy was immediately arrested, my lord. Thereafter, this honorable court, my lord, granted him bail, finding that my lord, this material contraband recovered is not within the commercial quantity. Therefore, my lord, the detailed judgment was passed by this from page 30 onwards. Therefore, my lord, finally, this honorable court was pleased to grant him, my lord, regular bail. Now, my lord, this petitioner before your lordship is also charge sheeted due to the statement made by the, my lord, co-accused, arrested accused person. In the meantime, my lord, he filed one bail application also before the trial court, my lord, and his bail application was declined by page 36, annexure 5 before your lordship. Here it was observed that, my lord, as the matter is already charge sheeted, there is no chance to take any coercive action against this whole petitioner before your lordship. Hence, my lord, for the time being, his pre-arrest bail application was declined. Subsequently, my lord, this petitioner also received from the trial court one notice, and pursuant to this notice, he also filed another, my lord, pre-arrest bail. His notice is, my lord, page 38, annexure 6. And he is willing and ready to, my lord.
What is the order granting bail?
My lord, the order granting bail is, my lord, relevant portion, my lord. It is starting from page 30, my lord, annexure 4, and relevant portion, my lord, operative part, my lord, as per my understanding is, my lord, paragraph 11, my lord, page 34, my lord. Observation and findings of the honorable court, my lord. On paragraph 12, my lord, page 34, thus, my lord, on perusal of the materials available in TCR, this court could not find any materials or document to show that actually the seized materials was weighted, excluding the plastic container bottles, to come to a findings that the materials which were seized is of commercial quantity. That being so, and taking into account the ratio laid down in the case of Hari Singh Supra, this court is of the considered view that at the stage, the benefit of doubt should be given to the accused applicant for granting bail at this stage, my lord. That's, my lord, he was granted bail. But when, my lord, he approached before the trial court, my lord, pursuant to the notice he has received to face the trial, my lord, learned trial court, my lord, apparently filed, passed the wrong order, my lord. This is, my lord, starting from page 39, annexure 7, and operative part is, my lord, page 40, my lord, second paragraph, my lord. Here, according to
The person who has been granted bail, he is the owner of the pharmacy.
owner of the pharmacy, my lord.
And you?
My lord, once upon a time, my lord, he worked under him, my lord, in the as a worker in the pharmacy, my lord. Therefore, my
And the
lord,
recovery was made from whom?
recovery was made from the pharmacy, my lord, when he was not in the pharmacy, because he was already, my lord, not working this pharmacy since long time, my lord. So, my lord, at this stage, my lord, my humble submission is that, my lord, learned trial court, my lord, observe that, my lord, police arrest and, my lord, detention during the trial is a two different thing, my lord. That cannot be compared with that, my lord. This is not, my lord, correct findings of fact, my lord, and law. Because Honorable Supreme Court already held, my lord, I have also annexed this judgment also, my lord, from next page, my lord, page 40, annexure 8, my lord. And here, my lord, Honorable Supreme Court very, my lord, categorically held, my lord, paragraph 9, annexure page 45, that, my lord, even, my lord, after charge sheet, my lord, anticipatory bail may be considered. But here it was declined, my lord. And, my lord, if, my lord, it is already charge sheeted, my lord, he will face trial, my lord, and he will, my lord, prove his innocence, my lord. Finally, my lord, at this stage, my lord, considering, my lord, your lordship may be graciously pleased, my lord, he may be allowed to, my lord, face the trial, my lord, without keeping him behind the bar, my lord. This is my humble submission before your lordship. Page, my lord, 45, my lord, relevant paragraph, my lord, paragraph 9, my lord. In our opinion, the High Court ought to not to left the matter to the magistrate only on the ground that the challan has now been present.
Alright, order dated 12/25. Three. Five, how many days in custody? Oh, no, this is
It's
pre-arrest.
a pre-arrest bail application, my lord. Now he is the, my lord, owner of the vehicle, my lord.
No, no, not owner. The owner of the vehicle, no. The vehicle, Aminul.
Ahmad Hussain Barbariya ki.
Granted bail by
Into state.
the High Court. By order dated 12/25 in of 2025. On the finding that the determination by the that the contraband to commercial was correct.
Special justice.
Payment of the expense done by excluding the containers. Circumstance, prima facie required intermediate quantity. Therefore, the rigor of section 36 fact that the culminating in the charge sheet. In the event necessary. They participate in the if one commences against him. Try to witnesses in any manner. Petition stand.
Development.
Your Lordship. The allegation against there will be theft of cattle traps, Your Lordship. FIR, Your Lordship, may kindly find 14. I read, Your Lordship.
Is received.
Did you receive money? Arrested one journal after on the basis charged the, my lord, scrap of one Sabir Ali, my lord, from Scrap of the Soberali, those my lord, those are cattle traps, my lord, recovered. And my lord, for his statement, the present accused Shahjahan Ali is the main person. The petitioner,
Recovery from him.
all those my lord, cattle traps were recovered from the scrap of the Soberali. For his Soberali, my lord, another accused person, Shahjahan Ali is the person who brought cattle traps to the scrap of Soberali, my lord. Shahjahan Ali is the petitioner here. Sober Enterprise, my lord, all those Abedin, my lord.
So other than statements of co-accused,
Present, my lord, only because all those, my lord, scrap cattle traps were recovered in the, my lord, in Sober Enterprise, who is owned thereafter on, yes, only on the basis. All those, my lord, cutter, my lord, those
for the petitioner. What is here? Call up the next case.
RDR is also rejected, my lord. Order can decimal page 17.
What ground has come up now?
New ground, my lord, 3 grounds have given. One is my lord's Article 306. The lordship, we have given some judgment also. And then there on the investigation, to our information might have been substantially progressed, my lord. And main issue is my father is serious state, my lord. You'll also kindly see that ground we have taken in paragraph page 14, my lord, ground number page 5. Cardiovascular ailments and has recently been diagnosed with multiple heart-related complications. Page 5. Basically, 06. Right. That my lord, I am the person who compelled. Lordship discussed in the judgment also, which we have referred that also, my lord. Basically, my father, my lord, is serious condition. There is none in my family. Or for a limited period also, my lord, your lordship may so that we
Where have you stated?
Yes, page,
Citing a father-
page 5. Page 5. New ground number 1 and 2, Your Highness. 1, command 2.
Yes, my lord, the materials in the support the contents of the allegation. Regarding the otherwise, my lord, now FSL report also received. FSL report suggests that yes, my lord, gave positive test for zinc phosphide. So, my lord, allegation is poison because of the my lord of the FIR also. It is specifically regarding my lord other allegation that my lord on the text of marrying her initially, my lord, love thereafter, my lord. Thereafter, my lord, he demanded money for marrying her, and thereafter, my lord, the allegation that she was sexually exploited, and he accused also blackmail her. Those regarding those allegations, there are, my lord.
I am not on merit, my lord, Your Worship.
My lord, I will.
For a limited period also, my lord, maybe, so that I can have. Your Lordship, my lord, Your Lordship.
Twelve, 11, 25. AB. Dispose of this for now. Send back this.
Obliged.
Uh, 35. And learn. Was arrested.
No, Your Lordship.
He was arrested.
One Joinal Abedin, my lord. He is the driver of the my lord, truck, my lord.
Joinal Ali. Hello, Sahid Ali. He was also.
Saber Ali not yet arrested. He has also filed anticipatory bail application that is pending.
Who has implicated? Joinal is implicated.
Joinal Abedin, my lord. Joinal.
Claims to be the owner. Maybe. Joinal Abedin.
Very grateful, Your Lordship. Years old, Matter Coxo, already. My friend was appointed as an investigator. For the external one, kindly see if I have paid 8 months.
অলপ implication আছে।
Page 8.
Have been implicated thoroughly.
And only page 4, paragraph 4, my lord. In case of my lord, their law was there, my lord. And ultimately came to know they have already settled the matter because marriage after the attaining of the majority, my lord. This is what information we got, my lord. Paragraph 4, my lord, just have a look to paragraph 4. Question was there, no doubt about both the party, but because of paragraph 4.
Any medical report is there? Been medically examined?
First statement, nothing happened, madam.
Only, my lord, that is a medical examine, but report, my lord,
When the allegation of is a forceful intercourse, medical report is relevant.
her statement, she fact implicated, my lord. Earlier refused, my lord.
That actually it has happened or not.
Is date of occurrence?
20, 25,
25, 12,
11. Oh, sorry, 12.
12.
12.
Her on the
Fire also same day.
same day. my lord.
Let us have the medical also.
When they consider why is 22 years, madam? How is there, madam? That is admitted both parties. Question, madam, age, madam.
There.
Now they realize their mistake, madam. Both the parties now come together, madam. Parents.
Why then why has nobody appeared? Medical also supports of sexual intercourse penetration. Yes. Yes. Medical and health officer Biswanath Sariali. Name is there. 17 years. As per the contained in FIR. Submitted on behalf fact girl and the love affair. Marriage. They were seen by the full stop para. Perusal of the CD, including statements before the IO as well as the magistrate, squarely implicate act of sexual intercourse minor. A prayer for free stand.
All eyes to.
May please, your lordship. Earlier, we have taken steps 3 times, lordship. We may be allowed to take fresh step through Dusty.
Prayed for by learned counsel for the petitioner. Steps by way of justice service. List again on.
Leave against acquittal, my lord, NIA case. Leave application. Leave appeal against acquittal, my lord, NIA case. Today is will may be taken up.
Respondent is here.
There was, while taking the amount, my lord, there was an agreement between the complainant and the accused person. The complaint agreement, it was, there is a clause, my lord, that if the accused person pay the money, my lord, they will, the complaint will file a money suit, my lord. Taking that ground, my lord, the order of acquittal has been given, my lord. Whereas all the ingredients under 138 have been complied with, my lord. Present, all the ingredients. I'll takes up the appeal memo, my lord.
Just a moment.
Page 48, my lord, it comes.
Respondent, as far as this leave application is concerned, learned counsel. Don't have copy.
Copy. Okay, they will receive.
The respondent has mandated. October. My case number 78 of 2020. Here is the skill. Instant IA. hearing. Not registered yet. is it?
After the leave is deeply obliged.
Then March করলো না?
My place of lordship. This is also regard. And they have appeared, lordship.
Yes, respondent.
Unless we have filed our wakalatnama, we have not filed memo yet.
This was issued upon.
As far as the leave application is concerned, any submission? The same order. Yes. For leave.
Deeply obliged.
As per office note, service is respondent number 2. Lordship, we have taken steps on 19/9/2020.
19/9. To take fresh steps.
Taken steps many times, but
No one has appeared means what is the report on service?
I didn't know what you want to say.
But condonation. Delay condonation.
amicus curiae may be. Amicus curiae may be.
I cannot have it without. No office note also. Is there? Office note doesn't indicate you have taken steps.
Have the
Submitted that the petitioner has taken fresh steps on 19/09/25. Two. No, give it early. It is only for verification.
May please, your lordship. Paying for leave against the order of acquittal, my lord. But there is a judgment of the apex court. Says, my lord, that in a case of an acquittal under 138, complainant will be deemed to be a victim and have a right to appeal under 37 proviso to 372. Earlier CRPC, my lord. Or in view of such the judgment, my lord.
Why is leave to appeal required then?
No, my lord, the appeal will lie before the district session judge, my lord. Because under 372, the
Who is
appeal,
the appellant here?
I am the appellant here.
Then go.
I'll have to go, my lord. The only question is limitation, my lord. Because the limitation
What can we do about that?
the lordship can provide
That is the law.
my lord.
That is the law, and despite that you have come here. What can we do
My lord, the
about the
judgment,
limitation?
my lord, it is my, the judgment came in April 2025. And we preferred the,
Going back, then the High Court can decide the matter of limitation. Whatever plea you want to take it there.
no, I'll prefer the appeal there, my lord. The only question is limitation. If your
That
lordship
is what,
provides that,
even on the limitation, whatever plea you want to take, you have to take it there.
your lordship kindly provides that if I approach the learned session court within a period of 1 week from today, then the limitation would not arise. The liberty to approach is different, but here is the question of limitation. It is always there. I can approach.
The case doesn't lie here. This court
May kindly
say
peruse
anything
this
about
judgment.
limitation. Judgment came later, whatever is there.
No, judgment did not come later, my lord. Judgment came prior in time. Judgment is of 8th April 2025. I preferred the application on 26th of May and the impugned judgment is 3rd of April. Judgment of the apex court came after the judgment rendered in this case, my lord.
Do you approach this court or
No,
before you?
before I approach this court. Before I approach this court. The case before the apex court, my lord, the apex court had granted the liberty that if the appeal is preferred within 4 months, then the question of limitation would not arise.
But you have to impress upon the court where you are going.
No, my lord. Been able to make myself clear, my lord. There, the question of limitation was condoned by the apex court itself in the judgment. That liberty was granted to approach, and if the approach was made within a particular fixed period, then the issue of limitation would not be raised by the trial court. My only submission before this honorable court is that lordship will give me time for 1 week. If I approach within 1 week, then the issue of limitation would not arise. That is the only submission, my lord.
Can pass any order, but under what provision do we pass?
Inherent power, your lordship shall always have, my lord.
Is it equivalent to 141?
But this is not under 141, my lord, but the inherent power lordships will always have under Ars 12,482, my lord. The end of justice, that power can always be exercised.
Contrary to the statute.
Not contrary, I would not say contrary to the statute, my lord. Because on a why the difficulty is
for the respondent. Full submission. 72 is very clear.
Eight four says the time for this honorable court is 60 days. But if we go by the Limitation Act, my lord, Article 114 says appeal from an order of acquittal. Because ultimately this will be an appeal from an order of acquittal, but by the judgment, I get the right to appeal on the proviso to 372. Here it says appeal from an order of acquittal under subsection 1 of subsection 2 of the erstwhile 417 of the CRPC 1898 is 90 days. But under subsection 3 of the section 417 of that code is 30 days. In my case, it will be 30 days. 30 days, I have filed on the 56th or 55th or 56th day, 53rd day.
What is your submission response? Objection. To means I have no objection. Third learned counsel for the pit. Submitted that. Petitioner intends to. Yes.
Kamrup.
By way of decision. In
Celestian Financial versus, I'm providing a copy.
where is allowed. Provided as prayed for by the petitioner and as agreed to by the event the approaches the alternate code below. The stands disposed.
Very carefully.
Give up the.
My lord, in this case, my lord, I have a similar prayer. Only period be given me, my lord, 15 days because it is a case of Tunsikia, my lord.
You may have a similar prayer, but where is the respondent?
Respondent has not appeared. Neither ID card or no.
Wait for that.
The Honorable Supreme Court has clearly said that the appellant can choose the forum, my lord.
The forum, but question of limitation will be there provided the respondent does not object, then only we can pass such an order. The
They have
absence
not
of the
appeared.
respondent, how can we say that the limitation period will not be taken into account?
Well, in that case itself, 4 months time was given, my lord.
After hearing the respondent.
Yes, my lord, that was there. It was there. But law is clear, my lord.
You have to take ID card or unserved notice get returned. Take fresh steps again after 3 weeks on.
May kindly have a look at the office note dated 1911, my lord. The ID card not unserved notice have been returned. Deal be taken, my lord.
Right, same order. Take 3 steps then.
May be fixed, my lord. Oblige.
Please, your lordship. Yes, I've been convicted under the NDPS Act for possessing intermediate quantity of ganja, my lord. We have preferred a bail application 1270, my lord. I-1270. Basic point, my lord, in this case, the 6 witnesses were examined, lordship. PW1 has said about sampling. I don't know what. It is about sampling. Sampling was not done before the magistrate, my lord. That is the basic point here. 10 years of conviction, I have already more or less 1 year, my lord, in prison, my lord. Present date, my lord.
I have not gone through the LC.
Lordship, they have filed an affidavit, my lord, in the matter. On Tuesday, my lord, I am not. It is on Tuesday, my lord.
Spread for by learned additional people. Again on.
Lordship, one prayer, my lord. They have filed an affidavit, my lord, but that affidavit is also not on record. So let it be tagged together.
Okay.
Objection, lord, sorry. Written objection against the bail application.
An objection said to have been filed by the prosecutor be placed on record.
May take it to court, lord. On Tuesday, lord. I am obliged, lord. 13 February.
May I please, your lordship? Lord, this appeal was filed, my lord, but at the time of filing, my lord, the application praying for leave was not filed. So subsequently, it was filed as IA number 636 of 2025. So notice may be issued, my lord, in appeal against acquittal, my lord.
And it counts for the. You filed the application.
Yes, yes, it's IA number, my lord, 636.
636 or 363.
No, ma, 363 is for condonation of delay, my lord. IA number 636.
63. Respondent. Two.
Two respondents.
May I please your lordship? Lordship, present my senior counsel. Another code, another matter. Kindly adjourn the matter for today. Another short date. I'll oblige.
But in this case, one of the appeal was preferred, my lord. They said petition for condonation delay. I thought that I have taken the steps, but from the office record is saying that steps were not taken. On a short date we given, my lord.
The petitioner 6.
Highly obliged, my lord.
February will be too early. That
Eight, please, your lordship. Kindly peruse the last order, lordship. There is no respondent number two, lordship. Sole respondent is the state, lordship. Even then, there is a direction to take step upon the respondent number. Your case, lordship. It is represented by the public prosecutor, lordship. However, there is a direction to serve an extra copy to the public prosecutor, lordship. I have served to the lordship.
any objection filed?
170 days delay in lordship. Refer this appeal, lordship. Found I have stated in para 5, lordship. This after the conviction, lordship, this person entered in jail, lordship. His wife, lordship, suffering from ailment, lordship, could not arrange, lordship, all this. 70 days delay. During this appeal, lordship.
Bandit count. Yeah. Five. Give the case.
Session case number 76 subject to the.
Instead. Occurred in favoring the stand. Hearing.
Highly obliged.
Please, my lord, 528 application, the passing application, my lord. Here, we have challenged the impugned order dated 21/3/2020 passed by the Learned Trial Court, the National and District Session Judge. My lord, in this, by this particular order, a charge has been framed under accused person under section 376, 417, and 313. That means rape, cheating, and causing miscarriage without consent of the woman. In this case, my lord, several steps has been taken to the respondent. Now, respondent had not appeared. And my lord, we are not having a stay in this matter. So I urge.
There is no service. Feedback unserved with postal remarks, insufficient address.
My lord, in this particular, here we have taken steps in the earlier address. Thereafter, there is a direction passed by this honorable court to upgrade and rectify the cost title and take steps into correct address. My lord, we have did that also in this particular matter. In spite of that, my lord, the notices always remain unserved to the respondent. That is why I'm urged this honorable court to take up this matter, my lord. At least to the extent that whether the further proceeding should be continued or it should be stayed. That is my humble prayer, my lord. In that regard, my lord, I would like to take my lord first to the even in the correct address of the respondent number 2, because the first is the state itself, my lord.
Is the corrected address?
Correct address, the address that has been reflected.
House number 12.
Post number 12, and this particular address is reflected in the format of the affair, not in the affair, my lord. Because this honorable court, looking at the format of the affair, that my lord will find at page 17. Here, 2 addresses have been mentioned. Format, my lord. In both the addresses, we have taken steps. No address is left out, my lord. Fix for evidence for tomorrow, my lord, before the trial. To correct address at paragraph number C, column Z. Oh, sorry, 7. One is house number 12, Konoklota Pot, Bhangagor, PS Bhangagor, Kamrup, permanent address Digboi Town, Postboy District, Tinsukia. In both the addresses, my lord, steps has been taken. In spite of that, it always remains unsolved. Therefore, my kind request before this honorable take up the matter today. Not express our lenience while taking the steps, my lord. That can be done, but my prayer should be considered. That is my humble prayer. We are ready to do that, my lord.
Application, the main application is for what?
Nothing, my lord.
Learned counsel for the petitioner. Or office note. Respected as the served with postal remark, quote, address. A perusal of the house title shows that of the rest by the house number, street name, the mark that the address is sufficient. However, the respondent number served through the sheet has already been trial. trial part don't submitted that the trial is commenced. Prayer is made to take further proceedings. Still on record. It fixed. Case number
258
Pended.
58 of 2024. Pending before additional Kamrup Guwahati.
The matter again on
To take this fresh steps, my lord, in this
to police station, you have to take
police
steps.
station, deeply obliged, my lord. Today itself, we are initiating the process, my lord.